Welcome again for those of you joining us and for those of you who have just joined. We're glad that you are here and with us for today's training. This will be a 75 minutes webinar on crimmigration and delinquent conduct, nuts and bolts for advocates serving unaccompanied youth. We are very excited to be able to offer this training today. And I want to begin by acknowledging that we know that delinquency adjudications and criminal proceedings can be a complicated area of law for immigration practitioners. There are also a lot of potential issues that can arise, and it would be impossible to cover everything in a 75-minute webinar. What we're hoping to do today is to address some of the key issues that come up and to provide foundational information about delinquency and criminal conduct for advocates serving immigrant youth. We'll begin with some housekeeping items and a short introduction to CILA. Next, we will discuss delinquent conduct with a focus on how to determine what is delinquent conduct and the immigration consequences of delinquent conduct. After that, we will turn to criminal acts and look specifically at the crime-based bars for inadmissibility. And finally, we will end with a short discussion about juvenile records and I'll close us out with some information about staying in touch with CILA. I am so grateful to be today to be joined by two amazing guest presenters. They are both champions for immigrants and immigrant youth and experts in the field. First, we're going to hear from Marion or Mickey Donovan-Caluste, who is the Legal Services Director at the Immigrant Defenders Law Center, or ImmDef, in California. She will be presenting today on delinquent conduct. We are also going to hear from Erica Schomer, who is a clinical professor at St. Mary's University School of Law in Texas. She will be presenting on criminal conduct and inadmissibility. We've shared their bios on the webpage that CILA's created for today's training, and I encourage you to check them out. Again, many thanks to both of them for taking the time to join us today and for sharing their knowledge with all of us. A few housekeeping matters that I'd like to go over at the start of today's webinar. First, if you have questions, we ask that you please use the Q&A function rather than the chat box to submit them. We do have a lot to cover today, so we likely will not have time to answer any questions live at the end of the training. However, my colleagues from CILA, Sachi and Nadia, are going to be monitoring the Q&A during the presentation. We also, I'll say in advance, would encourage you to submit any case-specific issues through a technical assistance request to CILA. And I'll provide some information at the end of the presentation about how to do that. The written materials for today's webinar have been shared on CILA's website. That includes the speaker bios that I mentioned, as well as a resource list and a PDF of today's slides. The slides do include hyperlinks to some of the statutes, cases, and resources that are being discussed today. You should have received an email about an hour ago from the ABA CILA Zoom account with a reminder for the training and a link to the webpage. We'll also be sharing a link to it in the chat. This training is being recorded, and CILA will post the recording on our website in the next couple weeks. CLE is being provided for today's training, but you must verify your attendance and attend the entire webinar to receive credit. I'll be providing a code verbally in the middle of the webinar, and you must take note of that because we'll be sending a verification form after the webinar for you to complete and return to CILA. We will also seek your feedback at the end of today's training. A survey will automatically open once the Zoom webinar ends, and we ask that you please take a brief moment to let us know what you thought of today's training, as well as any ideas for future topics to cover. A little more about CILA's training. Just a little bit more about CILA. As I mentioned, we are the Children's Immigration Law Academy, or CILA for short, and a project of the American Bar Association's Commission on Immigration. We focus on children's immigration matters, and we're a legal resource center and capacity building organization that is here to support all the attorneys, legal staff, and social services staff working on children's immigration issues. We think that children should not have to go to court alone, and that's a primary reason that we do the work that we do. In addition to legal webinars like this one, CILA provides a variety of services to support advocates, including written resources and technical assistance. We have a social work program in addition to a legal program that provides training and resources, and we also support pro bono programs and have trainings for pro bono advocates. We're based in Houston, Texas, but have attorneys located also in California or Chicago and other parts of Texas. And most of our services are now offered nationwide. The slides at the end will include some information about how to stay connected with CILA, and I also encourage you to check out our website where we share a lot of written resources and training recordings. Now we're going to jump into the heart of today's presentation, and I'm excited to turn it over to Mickey to share with us about delinquent conduct.
Thanks, Amelia, and thank you so much for having me. Actually started my legal career as a baby attorney on a fellowship embedded in the Riverside County Juvenile Public Defender Office, providing immigration legal services to system-impacted youth in Riverside and San Bernardino counties in California. So this topic is near and dear to my heart and very, very important. So thank you all for putting this training together. It's really, really important that practitioners understand this information. Next slide, please. So we got to start at the beginning. What is delinquent conduct? We need to understand whether our clients have been charged with a crime or whether they may have committed an act of juvenile delinquency as sort of the starting point in our cases. So what is delinquent conduct? Under the Federal Juvenile Delinquency Act, juvenile delinquency is defined as a violation of a law that it had been committed by a person prior to their 18th birthday, which would have been a crime if it had been committed by an adult. So that sounds pretty straightforward, but actually it's really a much more nuanced analysis because all states and the federal government have a bifurcated system for dealing with folks who have been charged with a crime or an act of juvenile delinquency. Juvenile systems or delinquency systems deal with minors, depending on the state. It could be minors under the age of 18 or under the age of 16 accused of breaking a law. And then, of course, all states and the federal government also have adult or criminal systems that deal with adults and certain youth accused of breaking a law. And then to make matters even more complicated, some states have a hybrid system called the youthful offender scheme that's sort of somewhere in between. And I'll talk a little bit more about that later. But the reasoning behind these bifurcated systems is that we understand as a society that a youth's culpability for a certain act may be mitigated by their age or maturity, such that they need different protections, different supports, and different consequences to address their conduct. And that, that's embedded throughout our legal system. We could look to the Supreme Court in the case Miller versus Alabama. That's not an immigration case, but in that case, the Supreme Court found that punishing juvenile offenders with life without the possibility of parole was unconstitutional, taking into account in part youth's sort of mitigated culpability in light of their age and maturity. So it goes beyond immigration law, but the difference has major implications for immigration practitioners. Next slide, please. So why does it matter whether your client's conduct was handled as a juvenile matter or a criminal matter? That's because in general, acts of delinquency are treated very differently from criminal convictions for immigration purposes, and typically, with an asterisk, do not carry the same immigration consequences. So it's really important for you to know how your client's conduct was handled. And this concept is really outlined in the seminal case Matter of Devison, which is a BIA case from 2000, where the BIA explains that juvenile delinquency proceedings are not criminal proceedings, acts of juvenile delinquency are not crimes, and findings of juvenile delinquency are not convictions for immigration purposes. Full stop. Next slide, please. But before you even get there, first things first, when you're working with system-impacted youth, it is really, really key to put in the work to build trust and rapport with your clients for a variety of reasons. Many system-impacted youth have interacted with multiple adults related to their criminal or juvenile cases. And some of those adults may have broken their trust. So they may have a delinquency attorney, they may have a probation officer, they may have interacted with police, with judges, with school officials related to their cases. And many of those adults may have promised them things and then those promises were broken. So it's really important that to understand that they're viewing you as part of that ecosystem as well, and they may have similar mistrust of you as they may have of other adults that they've interacted with related to their case. There may also be role confusion. It might not be enough for you to say, I'm your lawyer, so trust me, you can tell me anything. They may not really understand your duty of loyalty or your duty of confidentiality. You really have to lay that out and put in the legwork at the outset to show that you are a person that can be trusted, that you do what you say you're going to do, and that they have a clear understanding of what you're going to do with the information that they provide you and what you're not going to do. It's also really key to understand the context and keep it in mind that your client may be from a community or group that is disproportionately policed or penalized for conduct that perhaps if a youth in a different context had done it, there never even would have been an arrest in the first place. So making sure that you're keeping that context in mind, examining your own biases, and approaching your interactions with your clients with humility. And then finally, you want to be sensitive in preparing your legal applications for your clients who are system involved, including asking your clients to build, including asking them to build positive equities. I always think back to my time as a baby attorney. I was working with a client who had some juvenile adjudications for vandalism and multiple probation violations for dirty tests for smoking marijuana. And I was having him write a declaration in support of one of his immigration applications. And I sort of wanted to get him to say something like, well, when I look at my juvenile history, I feel so ashamed, but I've turned a new leaf, blah, blah, blah. So I asked him how he felt about his juvenile history and what he wanted CIS to know about it. And he said, well, it's not that bad. I was like, oh, yes, I need to take a step back and recognize that I'm making my client feel that, by building these positive equities, it's because he's in such a deep hole and he's made such horrible mistakes, but really, his conduct wasn't that bad. So I needed to reframe and rethink how I was approaching those conversations with my clients. Yes, it's important to build positive equities, but I don't need to make my client feel judged in the process. Next slide, please. Okay, so how do you determine whether your client's arrest or criminal or matter was handled as a juvenile matter or as a criminal matter? First, it's really important to understand that age is not enough. Many states have statutes that allow minors to be charged as adults for certain conduct or at a certain age limit. And those schemes either allow for automatic transfer to adult criminal court for certain law violations or allow for a process for transfer to adult criminal court in certain situations. So I practice here in California. And so there's an example from California, which is California Welfare Institution Code, Section 707, allows for something called a fitness hearing, where certain youth over 16, who have been charged with certain enumerated serious delinquent conduct, have a hearing to determine whether they are fit to be processed in juvenile court or whether the matter would be better handled in adult criminal court. So that's just one example of one such scheme, and many states have similar ones. It's very important to understand, and I can't emphasize this enough, that even if your client was a minor at the time, if they were charged and convicted in adult criminal court in the United States, then it is a crime for immigration purposes, regardless of whether they were a minor at the time or not. So it is very key for you to understand, regardless of your client's age, was this a juvenile matter or was it a criminal matter in adult court? Next slide, please. So how to determine whether it was juvenile court or adult criminal court? If it was in the United States, it's pretty straightforward. In most cases, you're just going to check and see if it was handled in juvenile court. Different states have different names for this. Some states, juvenile matters are handled in family court. In California, they're handled in a court called juvenile court, which deals both with delinquency matters as well as dependency matters. So it really varies by state. And then if your client was accused of breaking a law on federal land or certain federal criminal offenses, they could have been handled under the Federal Juvenile Delinquency Act, and that will be per se juvenile matter. And it's an act of delinquency and not a crime for immigration purposes. Again, if it was handled in an adult criminal court, it is a crime for immigration purposes, even if your client was a minor at the time. And then if it was handled under a youthful offender scheme, which I'll talk about a little bit more in a couple slides, you need to analyze whether that youthful offender scheme is analogous to the Federal Juvenile Delinquency Act scheme to determine whether it should be considered a crime for immigration purposes or an act of delinquency for immigration purposes. Next slide. Okay, for those visual learners out there, this is a flow chart that just reiterates some of the same analysis I just explained. So you'll be getting a copy of these slides, and if this is an easier way for you to parse out some of the text-heavy slides, this is there for you as well. Next slide, please. Okay, what about those youthful offender statutes? As mentioned, some states do have youthful offender statutory schemes that are typically a hybrid between adult criminal court and a juvenile court. And they typically apply to youth between the ages of about 16 and 21. So for an example of one such scheme, it might be that a youth is charged in adult criminal court, but if they meet certain conditions, their criminal conviction can be converted to a juvenile adjudication. So it's kind of, there's an adult criminal component, but also a delinquency component, and it can be challenging to determine how those should be viewed for immigration purposes. So in matter of Devison, the BIA lays out the analysis for how to determine which it is. And it explained that in order to determine whether a youthful offender adjudication is a crime for immigration purposes, the judgment needs to be compared to adjudications under the Federal Juvenile Defender Act. And in Devison, they found that New York's youthful offender paradigm was juvenile in nature because it was sufficiently analogous to the Federal Juvenile Delinquency Act. Next slide, please. So that's the analysis from Devison. There are many different states with many different youthful offender schemes. Some circuit courts have held that certain states' youthful offender schemes are not sufficiently analogous to the Federal Juvenile Delinquency Act, and they therefore are criminal. You need to look at the circuit law in your that controls your state. If you're in a state with a youthful offender scheme, I know off the top that DC's and Michigan's have been held by circuit courts to be criminal rather than juvenile in nature, as well as I believe South Carolina's. Okay, so everything I covered just talked about how to determine whether your client's US law violation was handled as a juvenile matter or as a criminal matter. But what if your client has a foreign adjudication from their home country? So the analysis is similar, but there's a bit more nuance. So first, step one, you need to determine whether the foreign law violation was for conduct that would be criminal if it had occurred in the United States. If it's for conduct that's not criminalized in the United States, then it's also not a crime for immigration purposes, and you can stop your analysis there. But assuming that the conduct was conduct that is criminalized in the United States, then you need to proceed with your analysis to determine whether that foreign adjudication or foreign conviction should be considered juvenile or criminal. And for that analysis, the FJDA similarly governs. So first, you're going to look at your client's age at the time of the adjudication to determine whether it even could be considered criminal under the Federal Juvenile Delinquency Act. So in matter of Ramirez-Rivero, the BIA explained that a Cuban youth who was convicted and sentenced to 20 years for breaking and entering into a home when he was 13 years old. And even though that was considered a criminal conviction in Cuba, because the FJDA, in effect at the time of his adjudication, didn't allow 13-year-olds to be treated in adult criminal court, that it therefore was necessarily a juvenile adjudication, even though Cuba treated it as criminal. So that's important to analyze when you're looking at foreign adjudications, is what was my client's age at the time this occurred? Assuming that your client was of an age that's sufficient that they could have been treated as criminal under the FJDA, then the analysis is a little more complex, which is laid out in matter of Delinquent, which is a 1981 BIA case. So in that case, a Cuban youth was convicted for conduct that occurred between the ages of 16 and 17. And because the FJDA, in effect at that time, allowed certain 16 and 17-year-olds to be treated in adult criminal court, then the burden shifted to the applicant to prove that it nevertheless was treated as a juvenile matter. And in that case, since the applicant couldn't, it was considered convictions for immigration purposes. So it still involves analogizing to the FJDA, and you need to be aware that the FJDA has been amended several times. So you need to look at the version of the FJDA that was in effect at the time, because, for example, the version in effect now does allow 13-year-olds to be treated in adult criminal court for certain serious conduct. Next slide, please. Another flow chart for your enjoyment that sort of outlines the same analysis that I just explained versus regarding foreign adjudications. Next slide, please. Okay. So you've determined that your client has a juvenile adjudication and not a conviction. Great. So you know now that there are different consequences for juvenile adjudications versus criminal convictions, but what are they? So for the most part, juvenile delinquency adjudications do not trigger immigration consequences. There's no need to look at the statute under state law and do categorical analysis or determine whether it was a CIMT. You can typically stop. I'm going to say typically, because I'm going to talk about some exceptions later. You can typically stop at, this was a juvenile adjudication, therefore not a crime for immigration purposes. Therefore, for example, doesn't trigger the particularly serious crime bar. Admissions to this conduct don't trigger, aren't admissions to a CIMT or admissions to a controlled substance violation. They're not crimes for immigration purposes, period. But as mentioned, they can be and usually are a negative discretionary factor. So when you're keeping this in mind, it's really important that you read immigration applications and all the questions very carefully. I hear from a lot of newer attorneys that say, oh, do I have to check yes to this question that asks if my client ever committed a crime? Because, you know, they do have a juvenile delinquency adjudication, and you need to take a step back and remember an active juvenile delinquency is not a crime for immigration purposes. So if the question says, have you ever been convicted? Have you ever committed a crime? Have you ever pled guilty or been charged with a crime? The answer can be no if your client has a juvenile adjudication and not a criminal conviction. But you do want to consider discretion. A part of discretion is, do you have these, arrests or quote unquote bad acts in your history? But another part of discretion is, were you forthcoming, or did you look like you were trying to conceal information that CIS might want to know about? So depending on the facts of the case, sometimes a good approach that some practitioners take is to check no, but nevertheless provide an explanation. So for example, if you know that CIS or DHS knows about an active juvenile delinquency, you might check no to a question, but then provide some information if permitted under state law to avoid the appearance that you're trying to obfuscate or, conceal information from DHS. Next slide. Okay. So when you're thinking through, when you're filing an application or proceeding in immigration court, you need to think through what you should disclose about the juvenile adjudication, what you can disclose, and what you must disclose. So an important consideration for whether you must disclose something is that a juvenile arrest is still an arrest. And so if the call of the question is, have you ever been arrested? You likely have to check yes or provide a yes explanation to that question. But do keep in mind that many states do have confidentiality protections for arrest records related to juvenile arrests. So even if you have to say yes, you still may nevertheless not be able to provide those arrest records if not allowed by state law. Okay, if you've determined you must disclose or you must not disclose, then you should think through, should you disclose? Again, you want to consider that the discretionary piece that, appearing to try to hide information from CIS that might be relevant to their determination is a negative discretionary factor. I say CIS, but it could be the immigration court as well. But you also need to consider that unnecessarily disclosing prejudicial information might violate your ethical duty of loyalty to your client or of confidentiality. So thinking through that sort of countervailing factor as well. And then you want to think through your audience. Are you filing at CIS? Is it at Vermont, or is it at the National Benefit Center? What do you know about adjudication practices at those two offices? Are you before an immigration judge? What do you know about that immigration judge? And how they handle adult criminal convictions versus juvenile delinquency adjudications. You need to think through all of that. And then you also want to think through what does DHS or the immigration court know or likely already or think they know about your client. So you want to look at FBI background checks, state criminal background checks, FOIA results, and if your client was ever in the Office of Refugee Resettlement, their ORR file, which is discoverable by DHS. So you have an idea of what DHS knows or thinks they know about your client, because that's obviously going to impact how you address any, prior history, and how in detail you go into explaining it. Next slide. And then you want to think about, can you disclose? Many states have strict confidentiality protections on juvenile records and case files. So again, California, where I'm sitting, has a Welfare and Institutions Code 827 and 831, which prohibits disclosure of juvenile documents and information to any unauthorized third party, and specifically mentions in the statute that that includes federal immigration officials. Without a court order. So you need a court order from a juvenile judge to make any disclosure. Even your client needs such an order. And if you disclose that information without a court order, it's actually a misdemeanor, punishable by a $500 fine in California. And then you want to think through, even if juvenile records in general aren't protected by those confidentiality protections, or even if they are, is your own client's case sealed or otherwise made confidential by the juvenile court? And what effect does that have on your ability to disclose? So again, in California, we have WIC 786, which dismisses and seals certain juvenile records and deems the arrest and other proceedings not to have occurred in certain circumstances, such as when the youth successfully completes probation for certain offenses. So it's really important to think through, if I even can get a copy of this, am I allowed under the law to provide these documents to CIS? And you might not be able to, and you might need to provide that explanation. Next slide, please. Finally, you want to think through discretion again when determining how to address juvenile records with an adjudicator. So it is, typically considered a negative discretionary factor, even if it doesn't trigger immigration bars. So you may want to offset with positive equities, thinking through providing letters of support from community members, evidence of volunteerism or community involvement, school records, awards, or certificates. You want to contextualize the adjudication in relation to any traumatic history, especially if you're applying for a humanitarian benefit. So I can think of a case where I had a client who had a juvenile adjudication for felony criminal threat on her mother. But I was able to contextualize that the mother was the same mother who had failed to protect her from the father's serious abuse of the child, and that was a basis for her SIJS application. And so providing that context. You might want to provide a declaration from your client, providing, context and or evidence of rehabilitation. And then if permitted under state law, you might consider providing evidence of successful completion of probation or other court mandated conditions. And then again, failure to be forthcoming or appearing to conceal the existence of an adjudication or appearing to fail to take accountability may also be seen as a negative discretionary factor. So you need to think that through when deciding how much and what to say about a adjudication. Next slide, please. Okay, got it. It's delinquency. So discretion is the only issue, right? Wrong. Next slide. Even though acts of juvenile delinquency are not considered crime for immigration purposes, there are some instances where they could nevertheless trigger immigration consequences beyond discretion. And so it's really important to be mindful of those as you're representing youth with juvenile adjudications. So probably the scariest and most commonly charged bar that's related to juvenile adjudications is that someone can be inadmissible if the government has reason to believe that the person has participated in drug trafficking or benefited from the drug trafficking of a parent or a spouse within the last 5 years. Typically, an adjudication for simple possession won't trigger, but adjudication for possession for sale or sales may well trigger DHS to charge this bar. It doesn't necessarily mean that it will definitely be charged. ImmDef had a case recently for a SIJS adjustment in immigration court where our client had an old possession for sale adjudication. DHS was aware of it. They did not charge reason to believe inadmissibility ground, but they did argue in the immigration court that nevertheless, it meant that our client didn't merit a favorable exercise of discretion. But the judge found that discretion was merited in light of the time that had passed since the adjudication and sort of evidence of rehabilitation. And key to that was also the fact that our client took accountability in court and was forthcoming about the prior adjudication. So that one's really key. If you have a client with sales or possession for sale, it's not the reason to believe is not waivable except for U's and T's. And so, really carefully advising clients if you're considering filing an affirmative application for someone with such a adjudication, you want to make sure you're providing really careful advice. Defensively, sort of no holds barred. Something to think through. Another ground that could be impacted by juvenile adjudications is inadmissible or deportable for substance abuse or addiction. Something to note about these grounds is that the mere existence of, a possession adjudication or a probation violation for failing to pass a drug test isn't sufficient to trigger this ground. A civil surgeon or panel physician must determine that your client meets the DSM-5 criteria for substance abuse or addiction. So the adjudications alone aren't sufficient to trigger, but it's something to keep in mind. And we also do hear that, well, I'm not aware of this ground being charged very much for adjustment of status, but we have heard accounts of panel physicians alleging this ground for folks trying to consular process. And of course, then the consequences can be pretty dire because a person may be stuck outside the country until they can show that they're in remission, which is more than a year since Pat's use. And then finally, your client could be triggering inadmissible for physical or mental condition posing a threat to self or others. We see this come up most commonly with alcohol use disorder and DUIs. So again, a civil surgeon has to determine this. Having a DUI adjudication is not sufficient to trigger this ground. But if a civil surgeon finds that someone has a has an alcohol use disorder, but nevertheless finds that there's no conduct posing a threat to self or others, and CIS has evidence of repeated DUIs, they may RFE for the person to return back to the civil surgeon to make sure that the civil surgeon is aware of the DUIs when they check that this ground wasn't triggered. So that's important to be aware of. Next slide. Then finally, or almost finally, we have a juvenile adjudication could trigger a deportability ground for violation of a domestic violence protective order. But it's important to know that for that ground to be triggered, there needs to be a judicial finding that a protective order actually was violated. It's not sufficient to just have a domestic violence adjudication. And then finally, inadmissibility for engaging in prostitution. It's important to know, I'm sorry, it looks like my computer's unplugged. 1 second. Okay, we're good. It's important to know that this includes being an adjudication for sex work and pandering, but not for being a customer of a sex worker. It's also important to note that any minor adjudicated for sex work related conduct is per se a trafficking victim under the TVPRA and would be probably eligible for trafficking protections, including a T visa if it occurred in the United States. And then also important to note that many states, including California, have moved away from criminalizing minors who have been trafficked. So in 2016, California changed the law so that rather than filing petitions in juvenile delinquency court for youth who were engaged in sex work, for minors engaged in sex work, they're instead being treated under the dependency system and not criminalized. So important to be aware of that context. Next slide. Okay, a note on marijuana. Even though many states have legalized or decriminalized marijuana, it's still federally illegal and still can trigger serious immigration consequences. And recent moves by the federal government to reschedule it would not impact those immigration consequences. So it's tough, but you need to be having those conversations with your youth clients. Remember that an adjudication for sales or possession of marijuana could still trigger the reason to believe drug trafficker ground. And of course, adult criminal convictions can trigger serious grounds as well. So you need to be advising your clients not to use marijuana, buy marijuana, or work in the marijuana industry, even legally within your state, until they become US citizens because of the risk of serious immigration consequences, even though under state law it may be perfectly legal. Next slide. Okay, a quick note on working with juvenile public defenders, because I have had in my experience as an immigration attorney, juvenile public defenders reach out to me for advice on sort of the best adjudication or avoiding immigration consequences for their clients because they're doing a good job. And maybe they're used to working in adult criminal court where those serious serious immigration consequences typically attach. So they may be reaching out to you for advice. So if you get such an inquiry from a juvenile public defender, first you want to confirm that it is a juvenile adjudication that's being discussed and advise them to prevent transfer from adult to adult court if at all possible. That's going to be thing one. Like if this is something that could be handled as a juvenile or criminal matter, you want to make sure that they stay in juvenile court if at all possible and not be transferred to adult court, because again, if it's in adult court, it will be a criminal conviction for immigration purposes. You want to confirm that the adjudication doesn't trigger a conduct-based ground. And then beyond that, it's kind of an art, not a science. You don't need to be engaging in complex categorical analysis. You want to sort of choose the adjudication that sounds the quote unquote least bad or least violent. Ideally avoiding gang enhancements or references to gang activity if at all possible, because CIS has indicated that they consider gang-related, violent, and sexual adjudications very heavily for discretion. Next slide, please. Okay, so I think we have just enough time for a case example to see sort of how much you've absorbed from my part of the presentation. So you have a client, 24-year-old Franklin, who was arrested when he was 17 years old for a fight he got into at school. He ended up hitting another youth with his skateboard, causing injury. He tells you he went to court where he admitted he did it, and he was placed on probation. He can't remember what else that happened in the case, though, since it's been so long. And so now you discover this when you're working with Franklin on his adjustment of status application. And you get to part 8, question 27, where it asks, have you ever pled guilty to or been convicted of a crime or offense, even if the violation was subsequently expunged or sealed by a court, or you were granted a pardon, amnesty, or rehabilitation decree, or another act of clemency? So how do you have to answer that question? I think there's a Slido, yeah. Okay, so how should he answer question 27 based on this conduct that occurred when he was 17 that he admitted to in court? And was placed on probation. Yes, Franklin said he admitted to a crime in court, so you have to check yes to that question. Or no, he was a minor at the time, so if he admitted to something, it was an act of delinquency, not a crime. Or no, he was a minor at the time, so if he admitted to something, not sure yet is the last option. You need to determine whether the matter was handled in adult court or as a juvenile. If it was an adult, you need to check yes. If it was a juvenile, you can check no, but you may wish to provide additional information, especially if DHS is aware of the related arrest. Okay, and you want to provide instructions on the Slido. Looks like people are getting it. So there is a Slido here. There's a QR code where you can go to provide your answer. Yeah, there's some instructions in the chat. Okay, so I can't tell how many people have responded, but it looks like 94% so far are saying not sure yet. which is right. We can't tell based on the bare information that Franklin provided whether this was handled in adult court or juvenile court. We know that he was 17, but again, age is not enough. He may well be in a state where certain conduct or all conduct by 17-year-olds are handled in adult court. So it's really important for you to get that information to determine whether or not this was a criminal conviction for immigration purposes or not, and therefore how to check how to answer this question. And it's certainly not definitely yes, because the call of the question is related to crimes, and this may be a juvenile adjudication and not a crime. Great. Next slide, I think.
Thank you so much. I want to thank everybody at CILA for setting this up, and Mickey for that excellent information related to juvenile delinquency issues that are very complicated. So I'm going to talk about what happens when we know a youth that we're working with was processed in the criminal system. So next slide, please. Specifically, we're going to be talking about the criminal grounds of inadmissibility, and the grounds of inadmissibility apply to different non-citizens. For our purposes today, we're mostly thinking about them in the context of applying for adjustment of status. So regardless of the amount of time someone has been in the US, when you apply to adjust status and get a green card, you are considered an applicant for admission, and you have to show that you're admissible to the US or you qualify for a waiver of inadmissibility. Next, please. So in the INA, in section 212, there's a long list of things that can make somebody inadmissible. So Mickey touched a little bit on some of the health grounds related to substance abuse. And what I'm going to focus on right now are the criminal bars under 212A2. But it is important, I always tell my students when we're looking at eligibility for adjustment of status to just go through, and I still do this more than 20 years later. I go through section 212A and I read all the things to look at which of those may be applicable in our client's case. And so again, for the purposes of today, we're focusing on the criminal grounds of inadmissibility at 212A2. Next. And before we get into that, I just want to put a big kind of caveat out there that because we're focusing on inadmissibility, it doesn't mean that criminal convictions or conduct can't cause other problems. They certainly can. So as we already heard from Mickey, they can be conduct-based health grounds, consequences. It could lead to a finding of a particular serious crime, which would be a bar to asylum or withholding. It could be an issue for establishing good moral character. I'm not talking about deportability under 237, and we already heard about discretion. So there are other materials that there's a handout with links to other materials that talk about some other consequences or problems that criminal convictions can cause. I am only focusing on the 212A2 inadmissibility today. So this is not applicable to say that if you're safe under this, it won't cause a problem. It could. Next slide, please. So under the crime-based grounds of inadmissibility, I like to think about it as 4 buckets of things. Crimes involving moral turpitude. We have some exceptions that I'll talk about. Multiple criminal convictions if the aggregate sentence of confinement adds up to 5 years or more. That's pretty rare, and I would say even more so for youth. And then we have our drug offenses, which include controlled substance offenses and drug trafficking offenses. And as Mickey already discussed, the reason to believe drug trafficking can be an issue, but also children who obtained any financial or other benefit from a parent's illicit activity, if they knew or should have known, can be found to be inadmissible. So that is another thing that, depending on the circumstances of your client, you may need to ask questions about. And then our fourth kind of broad category is prostitution and human trafficking. Next slide. So crimes involving moral turpitude is this amorphous thing that we see in immigration in lots of different places. Unfortunately, there is not a statutory definition of what a crime involving moral turpitude is. You have to do research. What the case law tells us is, I think, equally unhelpful. It means acts that demonstrate baseness, vileness, depravity, whatever that means. It changes over time. The BIA has said, well, you look to the inherent nature and seriousness of the offense, but just because there's a severe punishment, that doesn't mean it's necessarily a crime involving moral turpitude. So essentially, the case law is not very helpful. Things that have been found to involve moral turpitude include theft, fraud, and sex offenses, but not all the time. So what you really need to do is research case law. If you have a client who has a conviction, a theft conviction, you need to look at the case law to find guidance about what, at the time, because this has changed over time, the BIA says are the essential elements of a theft that constitutes a crime involving moral turpitude. So that part of identifying just even what the elements of a CIMT are can be difficult and is sometimes more difficult than the second step in the process. Next slide. For CIMTs, we have two specific exceptions, and I want to emphasize that these exceptions are only for crimes involving moral turpitude. They're not exceptions for the other crimes, criminal grounds of inadmissibility. So we have something that referred to as a youthful offender exception. It's very important to note that this has nothing to do with the state schemes that have youthful offender kind of adjudication systems. This is just an exception that applies to youth, essentially, is the best way to think about it. And so to qualify for that exception, it's a two-part test. You have to show that the crime was committed when the person was under 18 and that it was committed more than 5 years before the date that they're applying for a visa or their green card, right? So you have to show both the underage at the time and this passage of time from the date it was committed and also or when they were released from confinement, if they were actually confined for the incident. So if you have a situation where your client was processed in the adult criminal justice system, but they were under 18 at the time, first check to see if this exception applies, because if it does, then you don't have to do the other analysis, and this might be a quick solution to arguing that the inadmissibility grounds don't apply to your client. The other exception is what we call the petty offense exception. And this is essentially for a pretty minor crime. So if the maximum penalty possible does not exceed 1 year of jail, and your client was sentenced for under 6 months or less of confinement, then the petty offense exception would apply. And so again, you want to look at, you need to know what the statute was that they were convicted under, look at what the maximum penalty was, and then look at the actual sentence. And a lot of times, if for example, in Texas, if we know it was a misdemeanor offense, then we know the max is going to be 1 year or less. And then we just need to get the records to look at the sentence. So these are important exceptions to look at. Another thing to emphasize is this only works if there's one CIMT. So if you're working with a client who has multiple criminal convictions for things that could be CIMTs, then you're going to have to go into the more complicated test, which we're going to look at on the next slide. So the basic rules to figure out whether a criminal conviction has immigration consequences. First thing, you cannot solve this by just knowing if it's a felony or a misdemeanor. Unfortunately, there's still a lot of misinformation about that. That really doesn't help us. What you need to do is a categorical analysis. You need to look at the statute that defines the crime, not what your client did. And so this is really, really important, that it does not matter what your client did. It matters what your client was convicted of doing. And when you are doing this analysis of the conviction, we presume that the conviction rests on the least culpable thing that is sufficient to get a conviction. So you're going to presume the minimum conduct was done to satisfy the conviction. Under the rules of statutory construction, supposedly, if it is unclear, any sort of doubt in a section of conviction should benefit the immigrant. And so we always, it's very important to not get tripped up on something you saw in a police report that looks really bad, or something your client told you about what actually happened. You need to focus on reading the statute. Next slide. So our basic steps are first to identify the elements of the generic offense. And so when I say that, I mean, where in the 4 buckets under 212A2 is it? Could it potentially be a CIMT? Could it potentially be a controlled substance offense? Is it a prostitution offense? Are we looking at the multiple criminal convictions? So if it's a CIMT, to get your elements of the generic offense, again, you have to look at the case law to find out what the elements are to constitute a CIMT. Once you have a handle on that, then you're going to go to step 2. You're going to look at the state or federal statute that your client was convicted under and find that. So when you have these 2 things, then you go on to step 3, and you are going to compare the elements and figure out if there's a match. So if you have your generic definition and you have 3 elements, you need to look at your state statute. It has to have all 3 elements for there to be a match. If the state statute is missing one, it's not a match. And so that is the basis of the categorical approach. And your starting point to do this analysis to figure out if something is a CIMT, controlled substance offense, to figure out if it's going to trigger inadmissibility. So maybe this sounds simple, then it gets a little bit more complicated, because in reading the statute, sometimes we have different parts in the state statute. Next slide. So if we have a state statute that you're looking at, we need to also figure out if it's considered divisible. And what that means is that the statute creates distinct, different crimes. When a statute is divisible, so let's say it has part A, B, and C, if A, B, and C are different separate crimes, then and only then are you allowed to look at documents like the record of conviction or the plea agreement to figure out under which one of those, your client was convicted. And so you have to, in order to determine if something is divisible, you have to look at the elements of the offense and not the means. And so this is very confusing to figure out what is an element and what is a means to commit a crime. So I put up just an example of unauthorized use of a vehicle from the Texas Penal Code. So we have the person commits the offense if he intentionally or knowingly operates another's boat, airplane, or motor propelled vehicle without the effective consent of the owner. So just because a statute has the word or in it doesn't mean that it is creating a separate offense. You have to look at the case law for the state, or you can also look at jury instructions to figure out if something is an element of the offense or a means. In Texas, generally, the mens rea component is just a means of committing the offense. And we know that because the jury does not have to agree on whether something was done intentionally or knowingly. So under this statute, we have essentially three elements: intentionally or knowingly operating some sort of vehicle without the effective consent of the owner. And so if you read case law, look at pattern jury instructions, you will see that the judge does not have to make factual findings about whether the person acted intentionally or knowingly. A jury doesn't have to agree on that. They also don't have to agree on what kind of vehicle was operated. So in that modified categorical approach, you're going to have to look at your state case law or other resources to figure out whether or not a statute is divisible. And if it is, then potentially you could look at some additional documents to understand which subsection your client was convicted under. Next slide. So I want to talk a little bit about the analysis for controlled substance offenses. So on the left, we have what comes from the statute about the controlled substances ground of inadmissibility. And you will see that it includes state laws or could be foreign laws relating to a controlled substance, and then it references the federal statute. So your initial step in doing the analysis is you need to look at the federal statute and you need to figure out whether or not what the generic definition is under the federal statute, and then compare the federal statute to the state law to figure out if there's going to be a match. This could have something to do with the definition of possession or sale or something like that. But where there's a lot of litigation these days is actually looking at the drug schedules. Next slide. So in the Fifth Circuit, where I am, and the Sixth Circuit, for doing this analysis, if you find that there is a mismatch in the drug schedules, meaning the state schedule includes some sort of substance that is not listed on the federal controlled substance, then you have to do an extra step. It's not enough to just say, oh, the state of Texas actually criminalizes 3 things that aren't on the federal schedule. We win. It's overbroad. It can't categorically be a controlled substance offense. Sadly, that's not what we have to do in the Fifth Circuit. In the Fifth Circuit, we are required to show a realistic probability that the state would prosecute possessing whatever it is that's not on the federal schedule. And so a couple examples that we have from more or less recent case law. In Texas, the state definition of cocaine is broader than the federal definition of cocaine because it includes something called position isomers of cocaine. I don't know what those are. I don't care. All I care about is that that is a mismatch. And by showing that prosecutions have happened for that, you can make a successful argument that if your client has a cocaine conviction, that's not a conviction for a controlled substance offense for immigration purposes. Another example is synthetic marijuana. Again, it gets very complicated with what these substances actually are. But there too, there is a mismatch between the Texas drug schedule and what substances are included and the federal schedule. So it's very important if you are representing someone who has a drug conviction, you cannot just say like, oh, it's meth. Obviously, it's a controlled substance offense because I know meth is illegal to possess under federal law. That is not the analysis. You need to look at what the elements are under the state statute and compare that to the federal law and see if you can find an argument to be made that there's a mismatch and that it's not actually a controlled substance offense. Importantly, on the realistic probability test, this does vary by circuit. And so, as I said before, in the 5th and 6th Circuit, you essentially have to provide evidence that these other offenses are actually prosecuted. In the other circuits, there's a lot of litigation, but so I can't give you, I don't have a list of decisions by circuit, but for the most part, if you can show the mismatch on the schedules, that's generally enough to be able to make the argument that that there's a mismatch, and so it's categorically not a controlled substance offense for immigration purposes. So it is important, depending on where you are, to look at the latest case law on the realistic probability, because again, this is where a lot of litigation is going on before the BIA and in the circuit courts to challenge drug convictions, because as we know, or as I'll get to, with the exception of one conviction for marijuana, there are no waivers. So this is not something that you want to just give up and admit to if there's an argument that it's categorically not a controlled substance offense. Okay, next slide.
And
So,
Erica, just to provide a time check for you, sorry, because it is 3:04, so I don't know if you want to move past the next case example, and maybe we'll just leave this for folks to read and digest on their own.
Sure. Yeah, let's skip these two then. And so one thing in doing the research is to look at the tools that are already out there. So for those of you who are in Texas, the Immigration and Nationality Law section of the Texas State Bar had recently updated the immigration consequences of Texas criminal offenses. And if you join the section, there's free access to an updated chart. I believe the ILRC also has a similar chart for California. If you join and become a member, a lot of other states have resources. So I do encourage you to use those as a starting point, but you have to keep in mind that the case law does change often, and you should not just rely on a chart. And you certainly, for example, can't cite the chart as authority in your cover letter to USCIS, for example, and saying like, oh, it's not a CIMT. See the chart on the Immigration Nationality Law section of the State Bar. It doesn't have that kind of weight. So you do have to do research. Next slide, please. I want to talk a little bit about admitting criminal conduct, because in the statute, as you will see from the language that I have quoted on the right, it includes admitting that you committed a crime involving moral turpitude or a controlled substance offense. So what that means is that the person has to understand that the conduct constitutes a crime, and they have to have admitted the elements, that they committed all of the elements of the offense voluntarily. So it's harder than it seems to meet that test of having admitted criminal conduct. Next slide. So here's an example. We have Diego, he's 19 years old. He's attending his adjustment interview. And when you get to the inadmissibility part, the officer starts getting really aggressive because he checked no on all the boxes. And he says, "Come on, you really never tried weed." So Diego responds that, yes, one time he smoked a joint after school when he was 17. He got sick and he never tried it again. Next slide. So we have another Slido. Let's think about this. Has he admitted criminal conduct that triggers inadmissibility? I'll give you a couple minutes. Actually, I'm going to start talking through them because of time. So, no, he was not told the elements of the offense. Yes, he's under oath and admitted committing a controlled substance offense. No, smoking marijuana is not a crime. And then he was 17, so even though he admitted it, it's not a crime. So those of you who have said no, he wasn't told the elements of the offense, you're absolutely right. He was not told the elements of the offense. Those of you who said he was 17 years old, so even though he admitted it, it's not a crime. Well, that depends. And that goes into Mickey's kind of presentation, because in some states, 17 is old enough and you would be, and that could be admitting a crime. But because he wasn't told the elements, it's not. For those of you who said smoking marijuana is not a crime, I absolutely agree. There is no statute that criminalizes smoking marijuana. Possessing marijuana is a crime, but just because he says he smoked a joint, that doesn't mean he possessed it. Someone could have been holding that joint up to his mouth. And so saying you smoked marijuana, in my opinion, is not admitting that you committed a crime. And so although he is under oath, we have a lot of problems with what he said, and it doesn't meet the test because he wasn't told the elements. And again, consuming drugs is not per se a crime. The statutes penalize possession with intent to distribute, that sort of thing. And so it is more nuanced. And these are things that you want to prepare your clients for in how to answer the questions on the forums and how to answer the questions with the officers. Next slide. In the adjustment of status context for our SIJS eligible kids, we are adjusting under 245H. And so you have to have a visa available. They're already deemed to be paroled, and you have to be admissible or obtain a waiver. Certain grounds of inadmissibility don't apply. There's a link. You can look at that. Next slide. There is a different standard that applies for some of the grounds of inadmissibility, including one offense for simple possession of 30 grams or less of marijuana. And you can see the other things on this list. And the standard is a waiver can be granted for humanitarian purposes, family unity, or if it's otherwise in the public interest. Next slide. But for CIMTs, or multiple criminal convictions, 212H creates a waiver, but only under two circumstances. And generally, youth who are adjusting based on SIJ are not going to qualify because it requires demonstrating hardship to a spouse, parent, or child. to a spouse or parent, or that you're a child of a US citizen or lawful permanent resident. And then we also have a separate ground if the crime happened at least 15 years ago, and you can read those caveats. It's very difficult for a lot of youth to establish that, which is why you may really, really need to do that analysis and argue that it is not a CIMT. Next slide. So again, just to kind of give context for how we're doing this, first, we're considering that your client has a basis to has a petition that allows them to seek adjustment of status. You're going to review what grounds of inadmissibility apply, look at criminal conduct to figure out whether that actually does trigger inadmissibility. And if it does, then you have to look at whether there's a waiver available and what you need to present in support of that waiver. So I know that the end of that got very, very rushed, but there are other materials that you have links to in the handout. So I will turn it over for the rest.
Thank you so much, Erica. Yes, we have been a little bit ambitious with this webinar. There's, like I said at the beginning, a lot to cover, but you did a great job marching us through all of that. And I really appreciate all the information. We only have a few minutes left, but we did want to leave you with a little bit of a wrap up, just talking about juvenile records. Mickey touched on some of this, but when we talk about juvenile records, we're now back in the world of delinquency. So again, these are records from the delinquent adjudications. And as a starting point of all of this, you always need to determine, are you dealing with a delinquency or are you dealing with a criminal conviction? For juvenile delinquencies, they are state-specific laws, so it's very important to do your research and know what applies in your jurisdiction. As Mickey mentioned, in most states, and in fact, I would guess in a lot of them, these are confidential records. What that means in practice is that there can be limited access, meaning you might have to go to court, or it might actually have to be the person who brought the delinquency and represented them originally to go to court to request access to the record. As the immigration attorney, or maybe even the federal agency, they might not necessarily have access. There can also be confidentiality provisions about disclosure. So even if you got access to the records, what can you do with them? Are you allowed to disclose them? Are you allowed to use them in a federal proceedings? Those might all be limitations on the records. And there's also sealing statutes, which Mickey talked about as well, which are different from confidentiality, and they can present further limitations both on the access to the records and what you can do with them. So again, it's really important to do the research, and part of the reason that we're really not able to cover on a nationwide scale is that it's a big topic. We could do a whole webinar on juvenile records, but you want to kind of look at what it is. And when we say know where to look, that is the state specific, but also the specific agency. There's specific juvenile justice departments and agencies to look at. And so you want to know where to go and which clerk's office, because it might be different than the criminal adult court or the civil court. And then also knowing, as Mickey talked about, there can be different stages. So there might be an arresting agency that's different from the court and maybe different from probation. And so if you are trying to access the files, thinking through, have you seen everything? What are the confidentiality protections that apply, and working on that. Some just kind of quick practice tips on this to wrap this up. We've included some great resources on the handout list, and I think there was some questions about this as well related to it. But when you're talking about records and confidentiality, keep in mind that there are policy reasons why we don't disclose these, and these things shouldn't be following youth throughout their lives, and there's a reason why they're made confidential. And so you might want to be considering that when making the request. You, of course, want to always talk through these things. If you are planning to try and potentially not disclose with the client, think through the positive equities that might be involved with discretion and talk through them with them. Confirm any of the information that you gathered or hear about with the client. You may even want to have them sign a written statement. I know that when working with youth, it can be especially difficult, but we have resources at CILA that can help you in terms of navigating difficult conversations. And of course, make your FOIA requests. That can be to USCIS, EOIR, Customs and Border Patrol, or ORR, which is the agency that works with unaccompanied youth. We are unfortunately at time, and so as I alluded to, we are not going to be able to answer any questions. We are going to drop the feedback link, the feedback survey link in the chat, and please do look at those if you have time. I encourage you to check out the handouts with more resources. A huge thank you to both of our speakers, and their bios are available there. And please do look at the information that we're providing on here about how to stay connected with CILA. We hope to see you at a future training, sign up for a newsletter or working groups, and I will be sending a follow-up email with the CLE information. Thank you all so much.